Navigating intellectual property licensing agreements can sometimes feel like deciphering a complex legal puzzle. While the excitement of a new partnership often takes center stage, it is crucial to pay close attention to the clauses that define who bears the risk when things do not go as planned. So, what are some of the most common indemnity issues that arise in IP licensing? In IP licensing, indemnity clauses are fundamentally about allocating risk and responsibility between the licensor and licensee. The most common issues revolve around who pays for legal defense and damages if a third party claims that the licensed IP infringes on their rights, or if there is a breach of warranty related to the IP itself. This also includes issues like product liability stemming from the use of the licensed technology. The why behind these issues is deeply rooted in the inherent nature of intellectual property. IP rights, unlike tangible assets, can be complex to define and defend. For instance, a licensed patent might later be found invalid, or the use of a licensed trademark could inadvertently infringe upon an existing, unknown mark. Factors such as the type of IP being licensed, whether it is a patent, trademark, or copyright, significantly influence the specific risks. The scope of the license, whether exclusive or non-exclusive, and the geographic territories involved also play a major role, as does the relative bargaining power of the licensor and licensee. Additionally, the specificity of warranties provided by the licensor regarding ownership and non-infringement directly impacts the potential for indemnity claims. To effectively navigate these waters, both licenses and licensees must clearly define the scope of the indemnity obligations. This means specifying exactly what kinds of claims are covered, such as third-party infringement allegations or breaches of the license agreement itself. It is also vital to establish clear triggers for indemnity, detailing when and how one party must notify the other of a claim. Furthermore, setting limitations on liability, including caps on financial exposure and the duration of the indemnity, helps manage unforeseen costs. Understanding notification procedures and defining who has control over litigation are also critical practical steps to take. An important insider detail often overlooked is the distinction between the duty to defend and the duty to indemnify. While indemnification means covering financial losses, the duty to defend refers to taking over and paying for the actual legal defense of a claim. Often, an indemnity clause will specify which party has the right or obligation to control the defense, which can significantly impact legal strategy and costs. Carefully structuring reciprocal indemnities, where both parties agree to indemnify each other for specific breaches, is another nuanced approach that can balance risks. Ultimately, a thorough understanding of indemnity issues in IP licensing agreements is essential for protecting your valuable intellectual assets and minimizing potential disputes. By proactively addressing these clauses with clarity and foresight, you ensure financial security and a more stable commercial relationship, allowing both parties to confidently innovate and grow.